Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is May 19th, 2016. Every other Thursday, we have a community conference call, which this is, and we try to give our input to people's situations. As you would have heard when you logged into the call, this is not intended to create an attorney client relationship, nor is it an exhaustive consultation. We do the best given what we've got, but don't depend upon this as your only source of action. Okay, that said, folks, as usual, first thing I'll do is I'll run through the questions that I have marked as frequently asked questions. Each time I finish answering a frequently asked question, I will open the floor to follow ups on that frequently asked question. We'll go on like that. Once we finish the frequently asked questions, then we'll run through the questions that are not frequently asked. And at the end of all of it, we will open the floor to new questions. Okay. I was hoping to not to have to do new questions today because I have a lot to talk about. But at least one of you who has written to me is in a little bit of a rush. So I think I'll just finish everybody's new questions as well. I did not think that I was going to be able to do it. I've told our team that from next conference on, let's close the questions at 18 instead of 24, 25, 22, because if we close it at 18, that gives me enough time to take new questions. And I think that's only fair. So that said, we will do new questions this time, and from now on, we'll just reduce the number of posted questions by 3 or 4, giving me 15-20 minutes extra to answer new questions. Okay, let's get started, folks. By the way, if you want to tweet to me, I am monitoring my tweets also. My Twitter handle is immigration.com. You can see it on our homepage, immigration.com, or on our forums, forums.immigration.com. So feel free to tweet if necessary. Otherwise, just wait. We'll be talking anyway. The first question that I have marked as frequently asked question, this has come up quite a lot in the last few years. So what happens is I am doing my job, and they have filed. I'm doing my H1. They have filed my green card. I-140 is approved. Sometimes even 485 is pending. Now I want to change back to student status because, for instance, I got an MBA admission in Wharton, okay, or one of the good schools, which is part of my overall career objective. What do I do? Am I going to be able to get an F1 visa after having exhibited immigrant intent, which is obvious in filing I-140 or 485? Remember, filing of PERM is not exhibiting immigrant intent. I-140 onwards, it's immigrant intent. Okay, that's technically the way it works. Of course, if the issue comes up even when you have not filed the I-140, it turns out you filed PERM, or somebody has filed PERM for you, of course, government could create, somebody tweeted to me, that's just the follower. Okay, so PERM onwards, it becomes a question of immigrant intent. Okay, so Cora's question is, I want to go to law school. Good decision, Cora. Now, what if I ask my company to revoke the I-140? Will that help? Well, let's take a step back for a second. Technically, you are correct. If you have exhibited immigrant intent, getting F1 status should be very difficult. Okay. Now, folks, while I'm talking and you have a follow-up question, press *5. No new questions, only a follow-up question on this issue. Okay. *5 will tell me that you have a question, so I'll be ready for you by the time I end this conversation on this issue. Okay, *5 on your phone for a follow-up question. So it is correct that when you have exhibited immigrant intent, government can take the position, consular officers can take the position that you've basically taken yourself out of consideration for a non-immigrant visa like student visa. As a practical matter, however, I know many cases. There was a year, I think 2 or 3 years ago, where we had 8 students or 8 people who had a green card pending, some of them at the 485 stage, go to Canada to get their visa stamping, and they all got their F1 visa stamping. You know that converting to F1 can either be through visa stamping or through change of status through USCIS. I'm not sure I have one preference over another, nor am I sure I have a preference for consulates, but that's the way it goes. So bottom line is, theoretically at least, your chances are made worse because of the green card. I don't think withdrawal of the I-140 necessarily helps, but if you want to, you could. Maybe marginally it might help. Nobody can tell you what helps, what hurts, and what your chances are. Keep in mind, I have actually a client and a colleague a few years ago who had a similar situation. What I recommended to him, he actually went to my school, GW, here downtown in Washington, D.C., George Washington University. I suggested, because he was a patent professional, he actually stayed on H1. His company sent him work from their home office, and while he was living in Washington, D.C., he was working remotely for them. We did an H1B amendment, because on H1 you can go to school even full-time if you want. If you want to reduce your work to part-time on H1, you can. All you have to do is amend your H1. So that's another option. Stay on H1, work remotely for that company or some other company, at the same time go to school. Okay. Any follow-up question on this? Press *5. No new questions, please. Follow-ups only. Okay. There's nobody with the follow-ups on this. Next frequently asked question I am going to discuss is, what happens if the I-94, when you enter the United States, is given for a duration shorter than what you're entitled to? So let's say you got an H1 or an H4 approval all the way to 2018, but your passport was expiring or a mistake was made and you got an I-94 till only 2016. The bad thing about this situation is you have to watch out for unlawful presence. When you come to the United States and you don't realize that your I-94 was only till 2016, you think it is till 2018. Come 2018, you are at least theoretically subject to 10-year bar because you've lived in the United States after I-94 expiration for over a year. So be mindful of that. I think as a general policy, it's a good idea to just print out your I-94s once you enter the United States. If an error has been made by the Customs and Border Protection, they will correct it. Okay. Sometimes when the situation is right and you get into this 1 year or 180 days or more, or 1 year or more unlawful presence, sometimes we can get you reinstated nunc pro tunc, which basically means retroactively, and that takes care of all problems. But sometimes what can happen is, so you were here, then there's a year of unlawful presence, then USCIS gives you I-94 from that year forward. That whole situation becomes very dicey. Are you now subject to 10-year bar, not subject to 10-year bar? So it's best to be very mindful of this issue. For N.K. Gokana, who wrote this message, came back to USA on H4 and got the I-94 for a lesser duration, but later on got an H1 approved, and the H1 was given with a good I-94. I don't have one piece of information, Mr. or Ms. Gokana. I don't know how long your I-94 was expired, how much is the difference between expiration of the old or the H4 I-94 that was given to you during your last entry and the H1 approval date beginning. So that gap, if it's more than 180 days, you should consult with your lawyers or have a consultation with us if you like. But that needs to be evaluated very carefully because that has many ramifications. *5 if you have follow-up questions. Remember, errors made by CBP can be corrected by just going back to the port or one of the many CBP offices all over the country. CBP is Customs and Border Protection, the people you meet at the airport or at the border. Okay, so any follow-up questions on this? Press *5. Okay, there are none. Let's go on to the next frequently asked question. This is another one that comes up quite a bit. Should I be doing H1B amendment when there is a change of cities or changing projects? Now, there is some area of this discussion that's quite clear, and some area which has been made less unclear by the USCIS than they had it before they issued the last memo on this issue, after the decision on something called the matter of Simeo, which was the name of the case from which they made this clear. The law has been clear for the last 10-15 years that any substantial change in H1 job description or job location requires an amendment. Substantial change. So if you get a salary hike of, I don't know, 20%, should you be doing an amendment? I don't know. That's something you need to discuss with your lawyers. Maybe. 10%, maybe not. 5% change, maybe, well, quite definitely not. What if you are changing cities, let's say more than 30, 40, 50 miles, 60 miles away from each other? Should you be filing an amendment even if the client is the same and the project is the same as well? I think you should be filing an amendment. And I think that the Simeo memo makes that quite clear. Okay. So it is quite clear when you are moving beyond normal commuting distance, which can be 40, 50, 60, 70 miles. If you're moving beyond that, you must file an amendment, even if the project is the same. What that memo made more confusing was this. What if I'm in the same city, but my project changes or my end client changes? Should I be doing an amendment? And that's a question further down the road. Somebody on the next page has asked, in fact, let me roll that in here as well. And I'll just quickly read that also. I remember that from reading just a few minutes ago. Oh, I don't think I've marked it yet. This question from Prashant says, we are changing project, this one right here. He says, if we are changing project, and that means end client is changing, but it's within 50 miles, do we have to file an H1B amendment and change in LCA or both? So my take on this is, despite the memorandum making things more confusing, don't forget regulations of USCIS have a more superior place than merely policy memos. So USCIS regulations are quite clear. Any substantial change requires an amendment. In my view, even if you're in the same neighborhood, even if the same building, but your project is changing. Let me just check my Twitter. Okay, that's a new follower. If the client changes or the project changes or even the job title and job description changes, you should be filing an amendment. Each time this sort of change occurs, try to get a written opinion from your lawyers if they say an amendment is not needed. That way, at least the employer and the employee are partly protected. Okay. Going back to the original question where I had started. So change of cities, definitely you need an amendment. Change of projects, even in the same city, I think you need an amendment. Change of end client, I think you need an amendment. Even if there is a change in the chain of vendors and sub-vendors, I think you should do an amendment, because the government could say, the employer-employee relationship is affected. We don't know if the new prime vendor has a different control over the employee, the H-1B worker. Okay. So bottom line, you should do an amendment every time there's a change of cities, more than a normal commuting distance. And every time there is any substantial change, including change of project, change of end client, change of vendors, do it each and every time. Amendment, okay? Or discuss it with your lawyers and get something in writing that says it is not needed. Follow-up questions on this issue only. *5, please. Follow-up questions on this issue only. Press *5. There are none. Okay. Let's go on to the next frequently asked question. Impact of traveling while an H1 extension is pending. Well, folks, this issue also comes up quite often. And whenever you have an extension of any status, the rule of the thumb is usually traveling is not a big issue, but discuss it with your lawyers. Usually it is not an issue. So for instance, you are extending with the same employer or even transferring to another employer. And during that time, after you have filed the H1, you want to travel and you have a visa stamp, you could travel and come back. For H4 people also, they could travel and come back. Um, there are issues about the travel that you should be aware of. Make sure you discuss it with your lawyers, but as a generic legal statement, traveling during an extension is usually not an issue. Okay. Um, Sorry about that, guys. All right. So, getting back to the issue that Abhinav had raised, current H1B is valid 2016. New employment offer from another company. They are filing H1B transfer in July. I'm also traveling to India. I'm planning to travel on July 20th and come back within 3 weeks. While the transfer is still pending with the USCIS, can I travel? The answer is yes. While H1B, as long as you have a visa stamp on the passport, which is good and covers you all the way to the re-entry into the United States. USCIS has also indicated they would like for you to have a copy of your receipt notice, but they can actually check that online also. While H1B transfer, it asks the last entry exit details. Don't worry, if those details change, it is not a problem. Your H1B is still in pending status. Press *5 if you have a follow-up question on this. *5. Okay, it doesn't look like there is a follow-up question. Next frequently asked question is the issue of birth certificate. Also a very commonly encountered problem. Both in employment-based cases context, I have a Twitter notification. It's another follower. Okay, so thanks for following, guys. By the way, I do enjoy our social media outreach, both on, well, not both, but we have 3 fairly active outreaches, more than 3 actually. Our own website, immigration.com, you can post messages. You can post, and I answer them at least once a week, maybe sometimes in a couple of days. Depends on how many messages there are and how busy I am. You can communicate on our Facebook page. All of that is on our homepage. If you look at the top, YouTube channel, tweets, LinkedIn, Facebook, Google Plus, and apps, etc. So we are pretty active on social media. Feel free to contact me. So going back to the birth certificate issue, both in the employment context and in the family-based petition context, it becomes a problem when either there was no birth registered or the birth was registered 4 or 5 years after the birth of the person. In those cases, you are better off getting a certificate or a letter from the local administration where the person was born. In India, it is either a municipal corporation or a village panchayat, which is a village body that governs local issues. Sometimes it can be taluka. So there are variations to the theme, but the basic idea is whoever is or whichever is the local civic administration, you need a letter from them saying either that there's no record of birth or the record of birth was initiated on XYZ date. It doesn't help if just before government asks for it, you've registered the birth. Don't do that. Just get a letter of non-availability. Sometimes it's called a certificate of non-availability. There really is no particular format for it. All it is government saying, we don't have any record of this birth. And then you get affidavits from 2 people who were alive when the individual was born. They don't have to be adults. So what if I'm applying for my 92-year-old father? Do I have to get affidavits from somebody who was 21 when he was born? So that's what, 119 years old now? That's not going to happen. They just have to be alive. And even if that is not available, a person is of advanced age, then you can do tertiary evidence, evidence from other sources. So there are all sorts of possibilities there. It's usually not a big deal. And there is also DNA testing available. You can always volunteer to do DNA testing. Okay. Let me see the exact question from Hemaji. Hemaji says, I have 2 questions regarding my father's green card. Sister is a US citizen, applied for father's green card, consular processing. There's an RFE asking for father's birth certificate. Father's birth was not registered. He's 78 years old. Okay. We have an affidavit from a cousin who's slightly older. That is good. Get certificate of non-availability. That is going to be important. school leaving certificate, get affidavits from 2 people, okay? And definitely everything else that you can get if you don't have 2 affidavits would help. I can't really give you a list of various things, but there are so many things like ration cards, if there's any state level ID, or any government documents that give his date of birth. So you will need probably 2 affidavits, which would be a good way to go. If not that, if you got only 1 affidavit, get secondary or tertiary evidence. Next question she has is, the whole process has taken over 1.5 years. If he applies for a tourist visa, will he get it? Nobody can predict that. Sometimes they will give it, sometimes they will not give it. Technically, it is exhibition of immigrant intent, but for parents of US citizens or spouses of US citizens, they are more easygoing. Okay, that doesn't guarantee it, but it at least makes it worth the effort. But make sure there are no concealments in the application for tourist visa. Make complete disclosures to the government where the case is and what's going on. Any follow-up questions on this issue of birth certificates, press *5 on your phone now. Any follow-ups, *5. Okay. When I go to the next issue again, changing jobs after I-140 approval, if you think you have a follow-up question on this, press *5 now so I don't have to wait. If you have a question on changing jobs after I-140 approval. That's another frequently asked question. Now, there are 2 sorts of situations in changing jobs after I-140 approval. There are several variables, but 2 sorts of situations. One is the impending regulations. They are not yet finalized, but the regulation said if you change jobs after 180 days of I-140 approval, you have much greater protection. Under the current laws, if you change jobs after I-140 approval, you keep your priority date, but you lose your right to H-1 extensions beyond what is given if your old employer revokes/withdraws the I-140. Okay. So getting to the questions from ships, I have a perm approved and I-140 filed in regular processing by current employer A. Now I have an opportunity from employer B. They will process my green card as a fresh application. I've got 17 months left on my H-1B visa. So 3 questions. In pending approval of I-140, will I get extension of 3 years from USCIS? No. No. You will get H-1B transfer, H-1B extension for the time remaining, and you can actually claim 1 year extra if your perm was filed more than a year ago. But 3 years you will only get if the I-140 is approved, not if it is pending. Is it recommended to switch now? I don't recommend it. I think you should get your I-140 premiumed, and then get it approved and then leave if you want to. There are some reasons I have in the back of my mind for that suggestion. Will leaving in between pending process impact me in the future? And the answer is no, not really. I don't think that is a major issue, but do talk with your lawyers. I have one raised hand. If anybody else has a question, follow up on this, please press *5 on your phone. I'll get to your questions right away. No new questions, just to follow up on changing jobs after the I-140 approval or before the I-140 approval. So it makes sense, in my view, not to change until the I-140 is approved. But do discuss your issues, your case with your own lawyers, or if you want a consultation with us, let us know. Let me check my tweets. There is a notification. There's a new follower. Okay, going back to the I-140. So that's in a nutshell the situation. Now, there's only one raised hand on this. So let's go to that raised hand. This is from Texas. Texas, go ahead, please. You have a question for me?
Yeah, I have a question. Actually, it's not the same question, but I posted somewhere else. I didn't know that this has to be posted here.
Yeah.
So I'm asking you here if you are fine with that.
I can't do new questions right now. Okay, just wait till the end of the call. I'll take care of the new questions after I'm done with this call. Okay. So going back to the next frequently asked question. STEM OPT extension for consulting or staffing companies. Again, folks, I remind you, if you think you have a follow-up question on STEM OPT extension for consulting or staffing companies, press *5 on your phone right now. I'm going to discuss it. And actually, you did the right thing, Saji, by posting an excerpt from the Federal Register. This is very important. In fact, many of my colleagues have not really paid enough attention to this. Basically, what the government is saying is that if you have staffing arrangement, what does that mean? Or a consulting arrangement? What that means is you are not directly supervising the employee who is on OPT STEM extension on the site where they are working. You should not be filing for their STEM extension. So what they are saying, in my view, is that if you are not directly supervising on the client site, you're out of luck. You should not be filing for STEM OPT extension. So far, this is what we know, what we have seen of their comments, USCIS comments. I have not heard anything different from USCIS so far. So if they say something different, we'll let you know. But right now, that is the policy. The above paragraph means if there is no direct supervision, then employer should not be filing that STEM extension. Okay. You should be looking for direct full-time employment or employment in a situation where the consultant is actually directly supervising you on site. Okay. *5 if you have a follow-up question. *5. Okay, there is one. Let's go to Minnesota. Hi, Minnesota. You are on the line. Go ahead, please.
Hi, Rahulji. My name is Shyam Prasad, and you gave me a really good information right now. But I have some quick questions for you.
Ji. Go ahead, sir.
Yeah. Okay. So you said that there should be a supervision working at the client's location if I'm working for the client's location. So, for example, if I do have any other employee working at the same location, maybe in a different project, so can he act as a supervisor for me so that I can apply for the extension?
Shyamji, let me tell you how things have changed. If you look at the new regulations, the burden of compliance has been shifted to both the employer and the employee. So you are both liable.
Yeah.
If you go into less than ideal situation, it isn't just the burden of the employer. Like in H1, it is the employer's burden. If there is non-compliance, unless you are actively participating in that non-compliance, the employer has not filed the LCA. It's really not your fault. We can't hold you for that. But in the OPT context, STEM OPT extension, I think we can hold you responsible. So unless you have direct supervision in your project, I would be very hesitant to say that it's okay for you to file for a STEM OPT extension.
Okay, so actually the employee is not in my current project, but he is the same company. But can I make an amendment like my manager can inform him or give him the training situation or anything? Then is it possible?
That's what I just said. I said unless that employee is directly supervising you on an ongoing basis, I think it's a risky situation. Of course, your lawyers can, or your employer's lawyers can assess whether in good faith that sort of filing can be done. It is a question of supervision, because if you look at the training plans under 983, the employer is saying, look, I have enough resources and I'll make sure this gentleman that I'm doing the extension for gets trained and gets experience in these technologies. Unless they are directly supervising you, I think it's a very risky thing to
So actually, I have gone through the USA's website also. They mentioned that is there any necessary of having a mentor for him? So they mentioned no need of any mentor. If they answer some questions over there, and even my international office people also said that if you as you're working for the consulting firm, you will definitely work in the client location. That's absolutely fine. They just call me. I'm not sure that how comfortable it is.
I would like that to be the truth, but I have not seen anything from USCIS that says so. If your international students office has a memo or something from USCIS, or you dig out any information that says so, because right now, as you can see, this is plain English. It says that there are several aspects of STEM OPT extension that do not make it appropriate for certain types of arrangements, including temp agencies, consulting firms that provide labor for hire, or other relationships that do not constitute a bona fide employer-employee relationship. Now, there is two ways to look at this. Is this the same employer-employee relationship as we deal with in the H1 context, where the right of control is the most important thing, but not the actual control? I think, even though I'm being maybe conservative on this issue, so far, as of May 19th, 2016, I am advising our clients at least not to get into STEM OPT extensions unless we have our own supervisors in the project actively working on the site. Okay?
Okay, Ramji. That's what I want to know. Thank you very much.
Oh, you're welcome. Good luck to you. And of course, if you find something that says otherwise and you want to run it by me, feel free to do so.
Okay, I'll try for that. Thank you very much.
You're welcome, sir. Okay, let's go on to the next frequently asked question. Yeah, this has been a very tricky issue. Let's go on to the next frequently asked question. Effect of divorce on an employment-based case and cross-chargeability. Please feel free to raise your hand if you have a follow-up on this. *5 your phone. So what has happened here was that I got married in May last year. Wife was born in Malaysia. So we've got our green card in October. So got married in May, got green card in October. Wife has moved to New York and she's thinking of getting a divorce. Does this impact mine or her green card? The answer is no. As long as the marriage was in good faith and you didn't do it to get cross-chargeability benefit, there is no problem in a divorce that does not affect her green card or yours. Okay. Sometimes what happens is people are getting divorced. The principal beneficiary will call me. Let me just check my tweets. Followers. Okay. So the principal will call and say, I don't want to continue my wife's 485. They can choose not to. Or the wife can say, or the husband, whoever is the derivative can say, I don't want to get my green card through him or her. That they can opt out of it. Both principal and beneficiary can opt out of processing the green card for their spouse if there's a falling out. Okay. Nobody has pressed *5, so I'll go on to the next question. But if you have a follow-up on this issue, press *5. Okay. Just want to make sure I'm not missing anybody. Okay. Transferring H1 subject to cap and cap gap extension. This is a little tricky issue. First of all, you know what cap gap extension is. If your OPT is expiring after April 1st and you've got your H1 filed before on April 1st or the time given, then you are entitled to continue working until October 1st. But if a decision is made against you before October 1st, then you have to stop working and you have 60 days to leave the country. So that's a cap gap extension in a nutshell. Now, I've got my H1 going. Before October 1st, I want to transfer over to a new employer. Can I do that? My H1 is approved. So I filed my H1 in April, let's say it got approved in August. October has not yet arrived. Can I change over to a new employer? And I want you to please confirm this because USCIS is subject to making many changes. I have a tweet again. Okay, it's a new follower. So their opinions about these type of finer details, the nth level issues, are usually very changeable because they're not written down. So my understanding of this currently is this. You've got your H1 approval. Let's take two situations. In one situation, your current employer has not revoked your H1 before October 1st. In that case, as long as the second case, the H1 transfer gets approved, you are good and you are without any cap issues. Okay. But if the H1 gets revoked before October 1st and before the approval of the transfer case, you are back to cap. I hope that's clear. Okay. So, and that's exactly the case here. How soon can I transfer? And you can transfer before October 1st also, as long as those two requirements are met. But after October 1st, you can transfer without any problems. Even if the employer revokes the H1, you will be okay, at least from the cap perspective. Okay. Then your question number 2, again, folks, if you have any follow-up on this issue, press *5. Press *5 on your phone. I'll be graduating in September. There might be a bit of a gap between my graduation date and the start date of my H1B. Graduation date and start date of my H1B. Okay. How can we handle this in between period between my graduation and start of H1B? See, you have 60 days of quote-unquote grace period after your F1 is over. So I don't really know exactly what you're asking me. It's a little difficult for me to decide. Cap gap extension only requires you to get a new cap gap I-20 from your school. It doesn't require any special filing for cap gap extension with the government. So the way it works is you would file your April-based H1. In the meantime, you'll be contacting the school for cap gap extension OPT. They'll require proof of the filing, I think, maybe a receipt or something like that. You can check with the school. I'm fuzzy on what exactly they require, but basically you get a cap gap to I-20 issued. Let me check my tweets. It's a couple of new followers. Okay. A couple of new followers. Okay. So going back to the cap gap, it's not something special you've got to do. You're automatically entitled to continue working by virtue of cap gap I-20 that you get based upon your filing of the H1 April 1st, as long as your OPT is expiring after April 1st. Okay. So it's through your school's DSO that you get your cap gap I-20. I take it you don't have a follow-up question on this? Okay, let's go to the next. We had a lot of frequently asked questions this time. So remedy for denial of an I-485. What do I do if my 485 is denied? Folks, there are two kinds of remedies in immigration law. There are many, but two that are relevant to this issue. What does remedy mean? There's a problem, how do I solve it? That's a remedy. Legal name for that is called remedy. Sometimes it's also called relief. Relief is what you get after the remedy is given. So two remedies are usually available. You can file an appeal or you can file a motion to reconsider / reopen. Slightly different beasts. And motion to reopen is based upon new facts discovered later. Motion to reconsider is based upon inappropriately allowed law. So there is a slight difference between the two situations. But they become kind of fuzzy when you file an MTR. So in 485 context, you have only two remedies available. Either you can file an MTR, a motion to reopen / reconsider, mostly motion to reopen, or you can file a lawsuit. And that lawsuit itself is quite tricky because some circuits in the country, see, our country is divided into circuits. I don't recall how many there are. I know that California, Arizona, and all is Ninth Circuit, Seattle included. Seventh Circuit is our Midwest area. So there are different circuits, and different circuits hold different positions with regards to 485 lawsuits. Some will allow them, some will not. So typically, when a 485 is denied incorrectly, an MTR is the correct remedy. But wait, remember one thing. If you don't have an H1 at the same time, or an L1 or something that allows you to be in the United States legally, you have to begin a countdown of 180 days. And because if my 485 is denied today and that's all I had to maintain my legal stay in the United States, I am in unlawful presence beginning the day after the denial. So if I stay here more than 180 days, even if an MTR is pending, I will be subject to 3-year bar if the MTR is denied. If it is granted, great. So keep track of that. Let me just check my Twitter. New follower. Okay. But you can tweet to me as I'm talking in case you have something for me to look at. Okay. Now, so that in a nutshell is the remedies for denial of 485 adjustment of status, whether it is in the context of an investor visa or in the context of an EB1C, EB1 or EB2, EB3, or any family-based case. Any 485 denial you cannot appeal, you can only file an MTR. Okay. In your case, Paragji, because when you filed your 485, government is saying the priority date was not current, that's a question of fact. If they have mistakenly identified this petition as being untimely filed, you can definitely file an MTR and get it reopened. We do it all the time. But if they are correct, have a lawyer review your case, see if your filing was correctly done. If it was filed too early and the priority date was not current, it won't be accepted. Okay. Star 5, if you have a follow-up on this, star 5. I want to add one more point. I haven't looked at these details in this. Oh, you're here. Good. I hope you have. Okay. Let's see. This is Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania. Yeah, Pennsylvania, go ahead.
My question is under Share 23, which is slightly different than what you covered just now. This is regarding AC 21.
What do you mean Share 23? Is that you posted a question?
Yes, sir.
Okay, well, I haven't come to that point, so just hold on, okay?
Okay, thank you.
You're welcome. Okay, let's go back to our questions. I don't think we have any other frequently asked question. This one I already covered. Oh, there's another one. This is another important one, the last frequently asked question of the day. What if your employer wants to sue you? Hey, you're supposed to finish your project. Guys, that's a tricky issue. Okay, that's a tricky issue. There are some protections in H1B, not in L1, where liquidated damages clauses could be quite problematic for the employer. Okay, so if you get sued on liquidated damages, I have an article written on this and an opinion piece in a newspaper, legal newspaper, which you should look at. I'll show you where they are. What is liquidated damages clause? Let's say you and I enter into a contract. You are going to develop some software for me. And I figure this is going to be an all or nothing. If you don't develop it to the end and if it doesn't work, there's no way I can give an exact number of how much it's going to cost me to replace that, get somebody else to start the project all over again. So both you and I sit together and say, look, if you leave before the project is over, or if it doesn't work, then we both agree that it will cost me about $250,000 to get replacement work done. So when you do that kind of an assessment in advance and put that figure in the contract, if you leave before the project, you'll pay me $250,000. That's called liquidated damages. Normally, when you go to a court, you have to prove how much money you have lost. Let me check my Twitter. Followers, okay. So, you have to prove your damages. You have to prove what did you lose. So, for instance, if you developed software for me, it didn't work, and my actual damages, if I sue you, not liquidated damages, my actual damages would be whatever money I paid you, plus whatever money I'm going to lose because the software was not developed on time. That's called consequential damages. Sometimes they are available. Then I can also sue you for a replacement if it cost me more than what I paid you. Things like that. I'm not sure how much. It depends. A lot depends upon the state law. So one thing to remember is, what are you getting sued on? Is it liquidated damages clause? If it is liquidated damages clause, are you on H1? Because then you might have a protection. On L1, lesser protection. J1, all of them are the same category. So H1 has some special dispensations there. Okay. If you're being sued for actual damages, you could have a problem. So what you need to do is, in cases where you get sued, the smart thing to do is, well, first of all, this is a great country. Any damn fool can sue anyone. Okay. The problem is not that you can protect yourself against lawsuits. The aim and the objective is to get out of the lawsuit as quickly as possible and as cheaply as possible. So as early as you can get the case dismissed, the better off you are. Even that costs money. Lawyers cost money. Like in our area, typically even a sole practitioner would charge you $400 to $600 an hour for a litigation. You might be able to negotiate a little bit, but it's pretty expensive. Smaller cities, even say further down in Virginia, maybe $150 an hour, $200 an hour, you might be able to get a good litigator. So what I would do if I were you is first contact my own employer and say, look, I want to talk with your lawyers, the employer's lawyers, current employer's lawyers, and say, can you help me straighten out this mess? Many times these cases can be decided out of court. Maybe some money can exchange hands, or maybe the case has to be fought. So that would be my first point of contact. Second thing is if you have hired a lawyer to protect yourself, to defend yourself, you can do it yourself, but it's very difficult. You remember, this is a matter of state law. So you have to decide, the lawyers have to tell you which law applies to this case. So if you have a contract with a Seattle company, let's say you have a contract with Microsoft, it probably has a clause that says Seattle or Washington state law applies to this case, and you can only sue and be sued in Seattle. So in that case, you need a lawyer in Seattle, right? Even though you are living in New Jersey or California and your project was in Minnesota, you still need a lawyer where the case is going to be fought. Okay. So, and it's a matter of state law. But do make sure that your lawyers, your litigation lawyers, talk at least once with an immigration lawyer, just to make sure, because there are certain things we can suggest. I'm a litigator myself. I litigated for many, many decades before I chose immigration law, or immigration law chose me. But even now we litigate occasionally against the government in exceptional cases. Problem is that DC circuit is not the best circuit to fight the government. Many reasons for that. But we do these kind of things. And I provide litigation advice all over the country, including criminal defense when corporations are being dragged into courts over criminal offenses. Their defense lawyers need to talk with litigators. So make sure you talk with somebody on the immigration side who can perhaps give your litigators some suggestions. And some of those suggestions can be very meaningful, very useful. Take it from me, it is an important part of the process. Okay? So, can they threaten you? Yes. Can they sue you? Yes. Will you have to defend yourself? Yes. One thing I want to point out, if you go to our website, if you want to see my articles on this issue, go to About Us. I'm clicking on that. Go to About Us. And if you go to About Rajiv S. Khanna, and there you'll have articles written by me. Rajiv's articles. So when you click on this, I have a whole bunch of articles that I wrote over the last few years, not as many as I would have liked to, but here is an article on liquidated damages clauses. This is a good 30-40 page long article, I think. So look at all these articles and see if this helps your litigators. Otherwise, have them talk with somebody who practices immigration law. Okay, star 5 if you have a follow-up question on getting sued. Star 5. Okay, I see one hand up. Let's go back to that issue. Okay. This is from Oregon. Oregon, go ahead, please. Oregon.
Yeah, hi Rajiv. This is Sarathi.
Yes, sir.
Actually, I'm working for an employer, and I got an opportunity from a different employer. So H1 transfer is also in progress. I got my receipt. They have filed my H1 process in a transfer in a premium process, and I have the receipt. Now I'm planning to take that opportunity, but my current employer, who holds my current H1, is saying that I have an agreement for 15 months and I have to pay some amount, or else they'll sue me. So I'm not sure whether that agreement is legal or not.
I just answered your question in great detail. I just explained to you what you have to do. You have to get yourself a lawyer in the state where the case is going to be fought, and you have to take their opinion, and it will be a good idea for them to talk to an immigration lawyer as well. Okay?
Okay, thank you.
Definitely. Good luck. Okay. I think that's all our frequently asked questions. Now let's roll back to questions that were not frequently asked in the order that they were posted. And I'm going to run through these questions, and then I'll open, well, maybe we'll do it like this. Let's start with Amber Hassan. Father came to US in green card in 2007. Okay, then he lost his green card, but in the meantime, he had applied for his daughter. So the question is, does that case survive if my father loses his green card? And the answer is, I don't think it survives. I think that case is over. As far as I know. I mean, I could be wrong about this, but I don't think I am. My common sense says that if at any time during the pendency of the derivative petition or pendency of the petition for daughter, father loses his green card, you have to start all over again after they get their green card, as far as I know. Okay. Star 5, if you have a follow-up question on this. Star 5, follow-up question. Okay, here we go. This one is from, our neighborhood, Virginia. Go ahead, please. Virginia, go ahead.
Yes, and okay, so the case is no longer valid for her. So we just need to do a new petition then?
That's what I think, Amber. You can have it researched if you like, but I would be surprised if the answer is different. Let me give you a piece of practical advice. Instead of spending money on a lawyer, I think what you can do is this. Contact your local congressman's office. Okay? Call them up.
Okay.
Say I'm a constituent, I live in your area, and I have an immigration-related question. Can you get me the answer? Okay? Now, the congressmen typically have between 1 and 2 or even three staffers devoted to helping people with immigration issues. And they have inside contact with the USCIS. They will be able to get the answer free of cost, and they are happy to help because you are potentially their voters.
Okay, so you're okay, and just following up on this. She's also being sponsored through me. I'm the older sibling, so and that case has been going on for 4 years. So she's waiting in another queue as well.
Right.
Do you have any estimate of how long that will take, or should the father petition again, or she should just wait for the sibling petition to come in now?
The way I look at it, the more the merrier. Since she's entitled to apply in multiple categories, apply in as many categories as you can. Sibling category is backed up 13, 14 years. Let's go ahead and have her apply through the other category as
well. Okay. Okay, thank you so much.
You're very welcome. Good luck.
Mm-hmm. Good luck. Bye-bye.
Bye. Okay. Let's go on to the next question. This is from Deepthi, who says, I'm currently on H1B, valid till October 2017 for company A, 3 years left on H1. I-140 is approved, planning to apply for H4 EAD for my spouse. Job offer with the university, they're willing to sponsor my H1B and green card, but they can start my green card process 1 year after joining. I'm not sure whether my current employer holds I-140 or revokes. My status won't be affected, I guess, but the main concern is about H4 EAD. So how long does it take for employer to revoke I-140? It is unlikely. Anyone can give you an estimate. It could be a process of weeks. It could be a process of months. Okay. I would certainly recommend that wait till you get your H4 EAD approval and then change employers, because USCIS has said, look, if we give you the H4 EAD and then I-140 is revoked, we have the right to revoke the H4 EAD. Will they actually do it? Nobody knows. So certainly that makes your chances of H4 EAD maintenance much better. Can I port I-140 to new employer? And the answer is you can't port the I-140 unless you're an EB1A category or national interest waiver category. But you cannot. But you can port the priority date. That's what the government has been saying most recently. If company A revokes my I-140, should I have an approved I-140 with the new employer till the end of 6 years on H1B? No, Diptiji, that's not the way it works. So you still have 3 years left on your H1. So this is not going to be, extensions are not going to be an issue. As long as your H1 is filed before the 6th year as long as your green card is filed before your 6th year begins, so you've got a good couple of years, you should not have any interruption in your work. Okay. If you have a follow-up question, press *5, please. Follow-ups, *5. Okay, I'm going to the next question. I will be getting my I-140 in about a month. If I switch employers and refile for my perm, will I be able to port the priority date? The current thinking of USCIS is yes, you will be able to port your priority date. *5 if you have a follow-up question. This one was easy. We'll get to new questions after I'm done with these. So this one, okay. Prodigy 7035 says, I'm on academic H1B till the end of March 2016. I've only used up 1 year of H1B. I filed for an EB1A concurrently before H1B expired and currently waiting for EAD. I have now 2 job offers, one from the same university and a different university, both hiring departments. By the way, H1 wage determinations don't have to be taken from the government. Your university lawyer should be able to tell you. You don't have to wait 3 months to file an H1 because you're waiting for a prevailing wage. I can understand why some universities like to do that. It's a very, very safe method, but it's equally safe to use third-party sources, in my opinion. Okay, so is it better for me to wait for H1B to be approved and join on H1B rather than using EAD? I think it's less of a hassle if you use H1B. Are you on the phone right now? Press *5. Prodigy, if you're on the phone right now. Okay. Well, let me try to cover it as best as I can since you're not here. I think it's less hassle if you join on H1B. It's definitely less hassle. Okay. If you join on EAD, then in order for you to activate the H1B, you have to go outside, get a visa stamping, and come back. So if my wife uses her EAD, I've got my EAD approval, but I don't use it, is that activating my EAD? The answer is no. If you have an EAD, you haven't used it, you're still on H1. If your wife has an EAD, she's used it, you haven't used yours, you are still on H1. Also, if I'm getting H1B visa, apply for H1 visa for my wife is using her EAD, will it invalidate her H4 status? Yes. If she uses her EAD, she's no longer on H4. She's on authorized period of stay. If your 485 is denied, she'll have to leave and come back on H4 stamp. Yes. *5, if there are any follow-up questions. This issue, Nitya, is a very difficult issue to handle. Well, probably not. What happened in Nitya's case was, she was an F1 or he was on F1. Nitya could be a guy's name as well. Oh no, she is. It's a she. So my husband came as a dependent on F2 visa. I got my H1B in October 2015, but he did not get picked up in lottery himself. But he stayed on F2. Didn't realize that he was supposed to convert to H4. The key here is this, and this is very important. And this is just a preliminary opinion because this matter is so sensitive. You should definitely take a detailed opinion, have this matter researched. What happens is, if somebody is unlawfully present in the United States for over a year, which he's not right now, he's probably under a year right now, but in October he might be over a year, then they are subject to 10-year bar. The question is, when does unlawful presence for a student visa or derivative begins? And I think for a derivative, student visa we know for sure, F1 we know for sure, but I think it's the same law for F2. If their I-94, instead of having a date of expiration, says DS, duration of status, then there is no unlawful presence problem. They can just go get H4 visa stamp and come back, no harm done. If on the other hand, the I-94 of the F2 holder expired a while back, you've got a problem, okay? So in either case, seek a consultation, but definitely seek a detailed consultation if the I-94 expired, okay? *5 if you are here and have a follow-up question. I check my Twitter, okay? You are here, let's get to it. This is South Carolina. Go ahead, South Carolina, please. South Carolina, go ahead.
Hi, sir. Yes. I do see his I-94 did not expire. It's still active. So what do you suggest?
I want you to, Nityaji, I still want you to get a consultation. Let's just make sure there's no issue. Mm-hmm. I don't think it's an issue. My preliminary thought would be, since the I-94 has not expired, I don't think it should be an issue. But two things I want you to do. Check with your DSO that does this create any problems of unlawful presence for him because you had changed over and your service is over. I don't think it does. Mm-hmm. Second thing, just do a consultation with a lawyer also, just to make sure all angles are covered. There is a memorandum from there's a memo from USCIS. It's about a 55-page memorandum that talks about when unlawful presence kicks in. And there's a separate section for students. So somebody should review that memo with you, make sure that as far as humanly possible, there's nothing here that causes major issues for him. Okay, I think he's going to be okay, but let's just double check that.
Okay, I have a quick question to follow up for this. So I know his I-94 is still active. So in that case, can he file it from US or should he go back to the country?
It will have to be outside the United States. He could also go to a third country, probably like Canada or Mexico. But the thing is, can he do it? Yes. In the USA, should he do it? No, because he's getting close to, or he might be close to 1 year, 180 days period. I'm just not sure that's such a good idea.
Okay. His passport is also expiring, so can he apply it in here and then go back to country, or should he do it back in India?
How long does it take for the passport to be renewed?
He has the expiry date till next 4 months, and I think he can get a new one in a week or 10 days.
I think he can wait that long. I don't think that's a problem.
So, do you suggest him to apply for one passport here or go and get it in India?
No, I would get it here if it's that quick here. Why not?
Okay, because the confusion was he stayed more than 180 days, so I'm not sure, as he does not have any status, if he can apply for a passport in US.
I don't know the Indian laws on this issue, Nitya. Sorry. I can only
Okay.
advise you about U.S. immigration laws. I don't know what Indian consulate,
Okay.
what rules they have, okay?
Okay, but according to US, he can apply for passport here.
As far as I'm concerned, if it's just a week, 10 days extra, might as well get the passport and then leave. Okay.
Okay, all right.
Good luck.
Thank you so much, sir. Really
You're
appreciate
welcome.
that.
Sure. Okay. Let's go on to the next one. Panky111, Company A applied for H1B. I was in India. Petition got approved. Me and my family, spouse plus 2 kids, all got visa stamped. Valid till 2017. I traveled to USA alone. I was given I-94 up to passport expiration, which is June 2016. In November 2015, I transferred my H1B to another company, still in the process. Company has revoked my approved petition. So presently, I have received notice and receipt notice and pay stubs from company B. Can my family travel? I think they can. I think they can. This is a little bit of an interesting and weird issue because you did apply for an extension before your current I-94 expired. So does that in any way negate your family's H4? I don't think so. In my view, my best guess is, and now we are in a guessing zone because I'm not aware of any law that succinctly says one way or the other. In my view, yes, they can travel. Should I update my case to premium? I think it's a good idea. And the passport issue is a relatively minor issue. I'm not that concerned about it. They should give you an I-94 all the way for 2 to 3 years. Okay. If you're on the phone, press *5. Panky, if you're on the phone, *5. Okay, here we go. And this is New Jersey. New Jersey, go ahead, please.
Yeah, this is Panky here, sir. So, yeah, my question is on that, can they travel because my petition is already revoked by company A?
Yeah, I still
so can they travel?
See, because you have you filed another case for a transfer before the current petition or before you fell out of status in the current case. So you are maintaining good status. You're in authorized period of stay. Okay. I think they can travel. I could be wrong simply because it's a N degree tertiary issue, and I don't think there is any law on this issue. Personally, I think it should be okay for them to travel.
So, yeah, so my follow-up question on that is will they be allowed to enter from a port of entry because, at that time you need to have some valid status showing that you are authorized to get in. So, with a stamped visa, they can travel, they can board on a flight?
I believe so. And
okay.
I think what you could also do is, rather than debate the theory of your situation, I think that very good practical solution is just to premium your case. That's the end of the story.
Okay, all right. But again, in premium, I'm worried, if they give me with my old passport expiry, if they give me petition and I-94 only up to old passport expiry, which is up to June.
No, they won't. They won't do that.
They won't do that.
No.
Okay, that's great. And just last question on as a follow-up on this one is, do we have this 240 days eligibility from the date of filing petition in case of transfer? I know in case of extension it's from the date of I-94 expiry, but in case of transfer, do we have this 240 days from the date of filing petition or from the date of receipt, or is it any other date, that counter is from some any other date?
I don't know the answer to that question. I would have to look. I think it's section 8 CFR 274. I don't recall exactly what it says. My guess, and this is a guess, my guess is the law should be the same on transfer as well as extension.
Okay, I was looking into the Federal Register and...
Hang on 1 second. Hang on, I changed my mind. Sorry. Extensions are covered by 240 days, but transfer should be covered by AC-21. And AC-21 will allow you to continue working as long as the case is pending, not just 240 days.
Oh, okay. That's great news.
Yeah.
Actually, yesterday I came across Federal Register, and they have recently updated a law on February 2016 saying that 240 days from the date of filing your petition, and that's for H1B1 for like Singapore and Chile and not for like
H1B.
So I think like similar thing could exist. Yeah, could exist for H1B as well.
Look at there are if you have time, you can look at the regulations, 8 CFR 214.1 and .2, which I think .2 contains the H1 regulations, and you can look at section 274, which contains the 240-day rule. But I think your case is governed by AC21, which doesn't put a number of days bar. As long as the case is pending, I believe you can continue working. It's an interesting situation. I would always double check these issues. I never take anything for granted. If I have even 1% doubt, I go back and look at the law all over again. Have your lawyers do it. But I suspect your AC21 protects you.
Great. Thank you, sir. So you mentioned 214.1, right?
214.2, I think, because 214 is all the visas. 214 has subsection F as in Frank, that's for student visa. So F visa is kind of from the subsection F. H visa is under subsection H, H1, H2, H3, H4. So all of them are under subsection H. So that's kind of the way the law is set up.
Sure.
Okay.
Thank you. Thank you, sir, very much. Appreciate it.
My pleasure. Okay. Let's go to the next question. That was Panky. And this is Lakshmanacharyulu. Lakshmanacharyulu says, daughter's H1B was picked up last month. Subsequent process and approval are awaited. Meantime, her OPT expired. Can she continue her work? Yes, gap applies as long as her OPT expired after April, which it did. So just tell her to please get her gap I-20 issued through school. Okay. I don't know about the driver's licenses, sir, because they are a matter of state law. Every state deals with it differently. Excuse me, let me check my tweets. Followers. Okay. So therefore, I wouldn't care to comment about what the regulations on the driver's license are, but as far as the gap extension is concerned, that's not a problem. She'll be fine. Okay. *5 if there's a follow-up question on this. Please press *5 on your phone. Okay. No question. All right. Let's go on to. I don't think we have a whole lot of questions left. 3, and then we can do new questions. Okay. Ashish says, employer applied for green card on EB1, EAD and advanced parole. Got my EAD and advanced parole. Green card is still pending. Now my employer wants me to relocate to India. What will happen to my green card case when I relocate? You could convert your AOS to consular processing. Okay. Convert that to consular processing so that you can go for a green card interview in India, as long as the green card offer in the USA still remains. Can I get a job with different employer based on EAD received? I don't know which kind of EB1 you have, but if your EB1 I-140 is approved and 485 has been pending 180 days, you can take advantage of AC21 with any employer. Yep, AC21 portability is applicable. I think I was looking at, there were some doubts about whether AC21 is applicable to EB1A cases. I don't know which EB1 you have, EB1B, A, B, or C. We know for sure EB1A, extraordinary ability alien. We weren't sure actually. EB1B is definitely now subject to AC21, as is EB1C, international managers and executives. I'd like to double check this, but the last memo government issued on same or similar occupations has footnotes on this issue. In their footnotes, they have discussed this issue of EB1A, EB1B, EB1C, all of them, all employment-based categories should be able to use AC21 to port over to a new employer, as long as their I-140 is approved and I-485 has been pending 180 days. Star 5 if you have follow-up questions on this. Star 5. Okay. Next question is from Keshvulu. I'm on L1B. I was on L1B 2009 to 2012. Wife and daughter joined me later. They got I-94. End date was as my visa expiration, which is October 2011. Ouch. Okay, whereas you got 2012. Okay, I applied for L1B extension, including my wife, in September 2011, but got a denial notice. Wife was 34 weeks pregnant. Doctor advised me not to travel. Attorney applied for B2 visa on June 2012. When did their I-94 expire? October 2011. So after it expired, not a good thing. So my baby was born June 2012. I left USA with my family August 14th, 2012. See, between October 2011, when their I-94 expires, and when you left, which is August 2012, you left before 1 year, but after 180 days. It looks like they are subject to 3-year bar because that B2 was filed after expiration of their status. Your lawyer should have advised you that that's not going to help. Okay, so it looks to me they are subject to 3-year bar. And this is a fairly problematic issue. But since you have been outside more than 3 years already, oh yeah, hang on, you have been outside for more than 3 years already. So then you should be okay because you left in 2012 August and they had not been unlawfully present for more than a year, only more than 180 days, and you've been outside for more than 3 years already. So I think, yeah, it shouldn't be a problem getting an H4. They were not out of status for 2.5 months. They were unlawfully present from October 2011 till August 2012 when you left. Okay. So they were unlawfully present for more than 180 days, but luckily less than 1 year. And you can send stamping, for family stamping later, you can go for your own stamping first. Star 5 if you are here. Keshavji, if you are here, star 5. Okay. So yeah, that is the situation as I see it. I think you'll be okay. I think this is the last 2 posted questions. There was a frequently asked question. I covered that already. Then that was Prashant Imi. Vidya says, I'm in the US, I have a green card, husband is in India, I plan to apply for a green card for him soon. Meanwhile, if he gets an L1, is that a problem? Vidyaji, that should not be a problem because L1 visas are immune to green card pendency. So you should be okay. All right. Star 5 on your phone if you have a follow-up question. So pending I-130 should not stop his L1. No problem. Then Babu 8 says, I have a question regarding AC-21. I started my green card with employer A under EB3. I-140 approval, 1 year of filing 485, I joined B using AC-21. Then C filed my green card under EB2. After I-140 approval and 200 days of interfiling, I decided to continue with the current employer B and thought to send AC-21 letter. Yeah, that's fine. But I got RFE only for medicals and they approved my green card. Well, just make sure you keep documentation showing that your jobs all the way through, at least the most important is A and B because you got your green card while you were working for B. Make sure the job A and B, the green card job, hang on 1 second. Employer C had filed your EB2, sorry. So C's job description and B's job description should be same or similar. Just keep some evidence of that. You should be fine. Okay. Star 5 if you have a follow-up question. Okay, good. You're here. And this is Pennsylvania. Pennsylvania, go ahead, please.
Yeah, Rajiv ji, where I was confused was after 180 days and after I-140 approval, if there is an offer from new employer, then definitely I can use AC-21. This offer is kind of with us current employer, the
Yeah, I
employer
understand.
with whom I have been already working for
I
last
understand.
5-6 years.
I understand. Let me sum up your situation. You got your green card started and became eligible for AC-21 with employer A. You joined employer B, filed AC-21 through them. Employer C started EB-2 for you. You got your I-140 approval and green card approval through employer C as well, but you stayed with employer B. And the answer is, why not? You can do an AC-21 portability with the same employer. Nothing wrong with that.
Okay, and I did not send the AC-21 for the EB2 case because they didn't ask for me, so I did not send it.
You don't. That's why I said you didn't have any opportunity to do so. Just make sure that you have some evidence, like explanation of your job, and it may be a good idea to get a lawyer involved. Just make sure the jobs are same or similar. So the EB2 job and the job for employer B should be same or similar. That's it.
Okay, I have that, that my job duties are explained by my current employer, so that is same and similar to the one for the employer who filed for my green card.
You should be fine. Just keep it in case the issue comes up during naturalization. You can provide this letter.
Okay, so this much is sufficient to prove that there is no breakage of law.
There is no breakage of law anywhere. That's just the problem is there are holes in the law procedurally which nobody has been able to fill in, and this is one of those holes where my AC-21, let me rephrase that, where my green card gets approved before I can file AC-21. No problem.
Okay, thank you. Because I sent the first AC-21 through the same employer when it was for the EB3 change.
That's okay. That's okay too.
Okay. Thank you very much, sir.
You're welcome. Good luck. Okay. Anybody has any question, press *5, please. Any question? *5. I have one question only. There's a lot of you out on the phone. Okay, to make sure everybody raises your hands, guys. Because once I count the numbers, then I'm not doing it again. 3. Okay, I've got 3 hands so far. Nobody else has a question? Any question? New or old, doesn't matter. Okay. So then I'm going to go, okay, 4. I've counted 4. I'm not doing a 5th one, guys. You good? All right. Let's start with, let's see. I want to go in the order that you guys logged in. So let's go to California first. California, you had a question. I remember getting your email. You had a question about H4 visa stamping, whether you can go to a third country or you can send she has to go back to India only. Isn't that sort of what you were asking me?
That's correct. Yeah, that was me.
And
how are you doing?
Of course, I'm good. Yeah, no problem at all. She can go to a third country. The only difficulty in going to Canada is that you need a visa to get to Canada also. But it is my understanding that if you go by road or maybe even by plane to Mexico, there's no Mexican visa needed. So that's the only thing to consider. Otherwise, she can go to any country for visa stamping.
Okay, yeah, because the question was she came to US on F1 and then her I-94 says D/S.
Yeah.
And she got her H while she was here and she hasn't traveled outside the country system.
No problem at all. I don't see any issues. Let me think about this for a minute. F1, H1, yeah, no issue at all. Go for it. Okay.
Okay, will do. Thanks so much, Mr. Rajiv.
You're welcome, sir. Good luck.
Thanks.
Okay. Let's go to... Oh. I think this one is done. Oh, I missed somebody's... Sorry, guys. I put somebody's hand down. I don't know who it was. Let me just finish the other 2, then I'll come back to you. I'll ask for another set of hands. Okay. This one is Florida. And I think I've talked with this gentleman multiple times before. The name is familiar. Go ahead, sir. Yeah, go ahead.
Hello, sir. I'm here, sir. How are you?
Good, sir. How are you?
I'm good. Thank you so much for asking. Two questions only. One is, last time I went to Canada for stamping, and is it a possibility like a drop-off kind of thing for next time also, or I have to go back to India for stamping?
I don't think Canada has a drop-off process. This is a consulate by consulate process. Not all consulates follow the same process.
But I can go Canada again for stamping. There is no problem, right?
No problem at all.
Okay.
All right.
And the second is like might be for everyone in the group. Is there any traction going on for the issues of any EAD for the 140 approved cases?
Well, let me try to remember the regulations. I don't think the regulations, the proposed regulations, they're on in my blogs. It's so long ago that I reviewed them. I don't think they contained a provision. Yeah, they did not contain a provision for EAD after I-140 approval. What they said was this: if your I-140 is approved and it stays approved for 180 days, after that, if it is revoked, you still have the right to keep getting H-1 extensions with any employer indefinitely. That is the only change it made.
Okay, but there is no traction going on for the issues of EADs for 140 approved cases.
It's
right?
not, nothing like that is going on now.
Right. And any new changes going to for 140 approved cases?
I don't think anything is going to happen. Anything is going to happen before.
Okay, because I used to go through with your immigration.com blogs, but I didn't see any latest updates.
Yeah,
on that, so that's why
because there isn't anything new to report. Otherwise, I would have reported it.
Okay.
Okay.
Okay. All right.
Good luck, sir. Good luck.
Have a great day.
You too, sir.
Thanks.
Okay. So we are done with. How do I put this hand down? Now it's done. Connecticut, go ahead, please.
Hi, Rajiv ji. I'm on a H1B and the I-140 was approved. I'd like to know that if I can qualify, if I can qualify for the EB5 investment visa.
Sure.
In case if I file.
Sure.
In case if I file after 2 years to establish the business, can I come back to my EB2 with H1B, or should I go through new H1B lottery system?
No. You see, your question is really this. Your question is, if I have a gap of 2 years between an H1 and the second H1, do I become subject to the quota again? That's your real issue.
Right? Yes.
And the answer is no. The law says if your H1 was approved anytime within the last 6 years, you're not subject to the quota.
Okay.
All right?
Okay. And what? Yeah, and one more follow-up. A couple of more questions on EB5, please.
No
it will be quick. Can conditional GC,
Listen,
I know that EB5 gives the conditional GC for 2 years. During the conditional GC, along with the business, can I work for a full-time job? That's one more question. And when I have a home loan here, in US, any investment towards my enterprise, is it still considered as an investment, or is it the subject to the loan?
Okay, first of all, home loan does not diminish your investment, nor can it be used to increase your investment. Home loan is a separate issue altogether. Okay, it doesn't hurt you, it doesn't help you.
Okay.
Now, if I have an EB5, can I also work a second job? And the answer is, you can work 20 jobs because you have a green card. If your EB5 is approved, you have a green card.
Mm-hmm.
If you want to work 20 jobs, that's your choice.
Okay.
Okay.
So during this investment process, that we have to invest that 500,000 or 1 million in the beginning of that, when we start enterprise, or over the period of 2 years. Rajiv?
Well, the way it works is that your money is at risk. So I'll give you an example. We had a case last year where somebody put down, I think, $800,000 in a steel industry, and 200,000 they gave a promissory note based upon some property they had in India. So that's okay, because what you are saying is, here is the money, and here is my promise of more money, which is backed by mortgaging my property in India, which is worth a lot more than $200,000. So that is acceptable. But the idea is now the entire capital is at risk. Okay.
Right.
So before you go to before the USCIS, they want to see the capital at risk.
Okay. So they want to see that the capital before they approve for an EB5 visa itself. Okay.
That's correct. And if I remember correctly, I don't think you can put things in an escrow, or you might be able to. I don't remember. Some of these visas, like E2 treaty traders, treaty trader visa, or treaty investor visas, we put money in escrow. I don't remember if EB5 allows me to do that. I have never done that in the past few years because all our cases have been out and out investment. In fact, we have a case right now where somebody's on H1B and he took a lot of courses in real estate, and he's made an investment of almost $1 million, although he needed only 500,000 because he was investing in a targeted employment area. So I think there is some doubt about whether that was a violation of his H1 status, but there's no question he qualifies for EB5. So there's some interesting issues in EB5 area.
Sure.
Okay.
I'll connect with you that Rajiv offline that so we'll have more question I have.
No
but,
problem.
This information is really helpful.
No
Thank
problem.
you.
You're welcome.
Yeah.
Okay, now last hand I put down. I'm very sorry. Can you press *5 again, please? My apologies. I'm actually working on an iPad. I'm not used to it. I have 2 monitors and 2 computers at work. So let's see. Oh, this is Pennsylvania. Pennsylvania, go ahead, please.
Hi, Rajiv. This 140 new regulation law, when is it going to be becoming law? Any idea?
Well, regulation goes through a life cycle, like software development life cycle, or FLCD. There's a life cycle. So we are at the very end. You can think of it as not implementation. You can think of it as user acceptance testing. So we are at the UAT stage because government has published a proposed regulation. They have invited comments. Public has made comments, 50,000 comments. And government is now reviewing all the comments. And once they have reviewed the comments, they'll either publish the regulation or the regulation will go in a black hole. Chances are it will get published. Don't know when.
Okay, so we can expect something around maybe 2 months or 3 months.
That's your number. I'll say okay. That's just as good as anybody else's guess. Okay.
Okay. I have one more question. Last month visa, updates shows like EB2. It has the final action has been in October 2004. They have retrogressed. So that's looking like really long waiting time. So what is any idea on that?
I think those numbers will probably go back to approximately the same neighborhood they were before. There are some elements that need to be understood in the context of how dates move. Dates move according to certain principles. First of all, each country is assigned the same number of green cards, whether you are a country of 1.3 billion people like India or a small country like Vatican City of 600 people only. You have the same number of visas. So we know that the number of visas is not increased. We also know the number of applicants has not decreased. So chances of any sudden movement towards betterment are unlikely. Number 2 rule is that these are all statistical projections. These are not actual numbers necessarily. Government says, okay, so far in this quarter we've received so many requests for green cards at the last stage, so we can project the numbers for the next month to this point. Okay, so there is a statistical projection, and then there is a limit on how many visas they can issue per trimester. So there's a whole set of rules that go into this. You may not be able to find a straight line relevance in all these rules. My guess is that the dates should go back to approximately the same neighborhood they were.
Okay, Rajiv. Thank you very much.
Oh, you're welcome. Good luck, guys. I'll see you again in 2 weeks, next to next Thursday. Thank you for being here. I always enjoy talking with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.